on, let me see, which one are we here on? 2302-1665. Can I get appearances?
Gary Trask is appearing on behalf of plaintiff Branford Townhouses Cooperative.
Linda Jabber on behalf of Carol Vasquez, who is on Zoom.
All right, and I see Ms. Vasquez is present as well. So I received a notice for proposed entry of order pursuant to MCR 2.602 parent B, parent 3, and that was received by the court. And then shortly after that, we received a objection to plaintiff's proposed order served on the defendant's counsel on October 13th, title protective order regarding disclosure of police reports. So I've had a chance to review the proposed order, which is essentially a protective order with terms in it that many of which I put on the record. And I didn't see anything in the order that was above or beyond what we indicated. I didn't see anything in there that went above and beyond or outside of the bounds of what was stated on the record on that day.
So, Judge, I'm just going to renew my motion to stay because we have a hearing in the circuit court regarding this matter on Friday. We actually were supposed to have a hearing 2 weeks ago, roughly 2 weeks ago, but I stipulated to an adjournment after sending in an offer to the plaintiff's counsel, and they said that they needed an adjournment to speak to the board. I granted that adjournment. Otherwise, I stipulated to that adjournment. Otherwise, we would have been in front of the circuit court judge, and they.
Who's your circuit court judge?
Judge Gibson.
Okay. All right. Well, here's the thing. I mean, as far as the objection to the proposed order, so your appellate case is up on Friday?
Yes, the first hearing will be up on Friday, yes.
All right, well, I'm not gonna stay these proceedings forever. This case has been going on for far too long. But under the court rules, the objections regarding the accuracy or completeness of the judgment or order must state with specificity the inaccuracy or omission. And there's no specificity with respect to inaccuracy or omission. It's just you don't agree with my ruling, basically. And I understand that and I respect that. And you and your client certainly have appellate rights, but your objection is overruled. So this order will enter. However, I will sign the order, and the order will remain in the courtroom or in the court until next Monday. And then if we get an update about what occurs in court, and then we'll release the order at that time.
Okay, Judge, thank you. Just for the record, if you don't mind, though, I'm going to object to it in its entirety because I believe that there is no exception. The legislator hasn't carved out an exception for civil cases.
It's not lien material. It's not lien material. There is nothing in there that I have granted that is lien material. A police report with the witness's information, something that was not obtained through the Criminal Justice Information Network, is not lien material. The information that I have ordered released is names and phone numbers of witnesses, and that information was provided at the scene by those witnesses. The type of shell casing at the scene, again, is not lien information. So I understand you have preserved your appeal multiple times, Ms. Jabber, but with all due respect, you're wrong. And you can have it out in circuit court. That's my ruling. Your objection is noted for the record. You believe it's lien material, and the circuit court will work that out.
Thank you,
Go
Judge.
ahead.
You know, I was just going to say, so I further talked to the Michigan State Police, and so their explanation of everything was not that it doesn't matter whether it was lien material or not, but whether the police department had to use any of their networks or basically any of their technology that they have private access to, even if it's SOS material. So even if it's just a phone number, if they had to, for example, if they had to use, like, look them up in any of their systems, then it would be considered lien material.
No, if you talk to a human being, if I look at my court recorder right now and I say, Miss Maudlin, tell me your name and phone number, and you tell me your name and phone number, that is not lien material. And if I go back to my computer and I type her phone number into lien, that does not protect that material from being disclosed. It doesn't. I don't care what Michigan State Police told you, it does not work that way. And I'm confident that a circuit court judge, and certainly I think the record I made on that date is clear as to why I don't think the information is lien protected material. And that's my ruling. Your objections noted. The Michigan State Police do not, I don't know if they don't have a clear understanding of what the circumstances are or what my ruling was and how limited it was, and that a protective order was in place. But that's my ruling, and that's what we're doing with it. But if the two of you can send an email to the civil clerks on Monday, just whoever writes the email, make sure co-counsel is, or brother counsel is, or sister counsel is CC'd on that email, and let me know what happened at that hearing date.
Will do.
Thank you, Your Honor.
All right, thank you, everyone. We're all set. I'm sorry, I was muted. I had a whole conversation with you. You didn't hear. All right.
Oh,
This
okay.
is
Well,
20.
sure.
Yep, we're gonna get through it so I can get you guys moving. This is 2301-0919, the certified alignment and suspension versus Joe Walker. Can I get your appearances?
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter, certified.
Yes, Your Honor. Bill Colovis on behalf of the defendant, P38434. Again, on behalf of the defendant. At this time, we haven't. We've talked. We didn't have a resolution yet. I believe, and please correct me. I believe you're looking for certain invoices.
Well, I mean, this is my motion for summary, but I mean, I have requested certain invoices from my client with regards to this, because based on our discussions with regards to his disputes.
Yeah, so I have this motion for summary disposition, and the motion is essentially, I mean, it's short and sweet and to the point. There were requests to admits on the case that weren't submitted timely back to the plaintiff. And then Mr. Colovis, I received your answer that says you never received discovery.
That's right. That's right.
And Your Honor, my only extension to that is, again, and I've written the affidavit, and I do have a copy of an email where I reached out to Mr. Colovis on September 18th, asking him for the discovery responses. I figured that would have prompted a response. I mean, I know it's a technical argument, Your Honor, and I understand where the court may go with this, but and I still haven't really gotten any clarity as to this, and I don't see how my office didn't send them to him, because they were forwarded. I'm not going to lie to the court with regards to that. So
I understand.
Well, listen, I think both of you have integrity, and I take you at your word. You're officers of the court. But if you're saying you sent something and he's saying he didn't receive it, was it just sent by regular mail? Well, you want to just tell me what it says and the date on it? It's to Mr. Colovis. It said, I'm writing to follow up on the status of your client's answers to our discovery or a possible offer, as I know you were talking about offers with my partner. Please advise. It was sent on September 18th, Monday, September 18th at 2:23 p.m.
Yes, it says discovery. It never says request to admit.
Well, I understand that. Listen, we're fighting over technicalities. Anyone who's an attorney knows that if you hear the word request to admit, all kinds of flags and panic is going to happen because of the consequence of not responding to request to admit. But Mr. Colovis is alleging he never received them. I mean, I'm not inclined to let this case go on forever. I mean, I can't, whether or not you sent them, Mr. Kim, and whether or not he received them. I mean, there's nothing in that correspondence that would indicate to me, and I'm not doubting that you sent them, of course, but whether or not he received them, I think is a question of fact. But the bigger issue is, how are we going to move forward on this case? It doesn't seem like the two of you are communicating very effectively, and we're here today for a settlement conference. So at this point, I'm denying the motion, or I'm at least holding. I mean, if there's more information that I need to consider, I'll reconsider it. But for the purposes of where we are today, I'm denying the motion. But we need to do something.
That it be set for a bench trial. It's a very minor amount.
Yeah, that's fine, Your Honor, because it does seem like it's going to be a he said kind of situation, unfortunately. Hopefully before then we'll be able to resolve it. But again,
and if you have any of this written proof that we talked about earlier today, please forward it to me. I will. Again, but I need your office to communicate with my office as well, because I mean, I've reached out multiple times. I'm not trying to play hide the ball here by any means. Again, I've reached out, I've contacted and emailed, and you know, again, I know you've got jury trials going on and you're busy at this point, but I do.
But again, I can't dance without a partner.
I agree with you. And
here's what I'm going to do. Listen.
That.
Here's what I'm going to do. I'm going to have them set a bench trial downstairs. How long is the bench trial going to take?
Half a day.
How much time?
Hour and a half.
Yeah, not too long, Your Honor.
I'm going to write down 3 hours just so everyone can get in the building. And we're going to have to send you out the date in the mail because we're going to have to find a block of time with 3 hours on it. So we'll get that done. And then in the interim, I am going to give you guys, discovery at this point has got to be closed. You're here to see me. So we're going to do a final conference. And we're going to do that in 3 weeks, if that works. Because and the only reason you guys are coming back to see me is so that both of you can say, yes, Judge, we have worked on our communication difficulties. We are in communication with each other and we are giving each other the things that we're asking for so that we can move forward with this case. And I'm going to say, that's great news. Do you have a settlement? Or are we going to continue to the jury or the bench trial date? Doesn't that sound good?
It sounds a bit spectacular, Your Honor, but I do have one caveat.
Right,
I have one caveat.
That's why you're the judge.
Yeah.
I have one caveat. I will be out of the country starting Thursday until the 5th of December, and I'm going to Asia. So if we could maybe push it out to like 28 days, just so I have enough time, or maybe 35 days.
I'm not going to ruin your vacation or your trip to come here on a matter that has 2 attorneys on it. So let's just, what's 1 more week? But the jury, the bench trial date might be in January. I hope it is. And obviously, you guys can figure this all out before that date, but I'm not going to, set the bench trial too far back for this 3-week or 4-week final conference. So we can do, what day is it, Amy? It's Tuesday. We do the, you say you're getting back the 5th, counsel?
Yes, Your Honor. And I'm coming back from China, so I will have barely any access to any sort of internet, unfortunately, because Google doesn't operate in that country. So.
Okay. We're good. I'm not going to have you do any of that. We're going to go to the following week. I'll even let you have your weekend home to get your life back together.
God bless you, Your Honor.
Yeah. Can we do the 9th or the 11th of December? Let me see. Check those 2 dates and my clerk is checking.
9th is a Saturday.
I'm great. I'm great on the 9th.
I'm looking at January. I'm sorry. I'm looking at the January. All right. So we would come in on either the 12th or the 14th. Okay. That may look good. Sorry.
I'm completely open on the 12th. The 12th of January is Friday.
We're talking about December.
Oh, you're back to December?
Well, we're not setting the trial date. I'm setting this final conference date.
The 12th of December, I'm perfect. I'm wide open.
I'm a little jammed, but if we do it around 1 o'clock, I can definitely do it. I have a mediation at 2 and I have a couple morning hearings.
Okay. Yes. All right. December 12th at 1 o'clock.
Perfect.
Via Zoom, and I'm writing on here so I remember, did they communicate?
Right.
Okay. Give each other
one of those. So it's Communication for Idiots, those books, Communication for Idiots.
Yeah, you're gonna have to, or you're just gonna have to come to court for everything, Mr. Kolovas. I'll solve all your problems. We'll just set dates to make sure you're effectively communicating with the world.
I've always said you're the best judge in the world.
Aw, that's so sweet. Okay, 12/12 at 1 p.m.
Great.
Did they communicate, documents exchanged? And I know the answer to both of those is going to be yes.
Yes, Your Honor.
Absolutely.
All right, great. And Mr. Kim, I hope you have a safe trip and that you have a nice time.
I hope so as well, Your Honor. Thank you.
Really,
for
yeah. Have a
accommodating.
super safe trip and enjoy. Hopefully, it's family you're seeing.
Oh, yep. My wife's family,
Great.
but yes.
Wonderful.
All right. Have
Smart
fun.
guy.
We'll see you on the other side.
All right, thank you.
All right. Bye-bye.
All right.